All right, how do you want to divide your time?
We'll have 2 minutes.
2 minutes? Okay, so I'll hold up a little sign at 10 minutes, 5 minutes, 1 minute, and 30 seconds. And once I kind of see, some part, I'll see your eye kind of observe, and I'll put it back down. Seems to be about what I did.
Y'all ready?
All rise.
Oh, wait, I don't.
The Honorable Judge Goff presiding. God save these United States and God save Mississippi College School of Law. Sorry.
I don't know who's first. You may be seated on defense.
Ready, Your Honor.
You may proceed.
Your Honor, may it please the court, before I begin, I'd like to reserve 2 minutes for rebuttal. Good evening, Your Honors. My name is Sam Newman, and I'm here tonight on behalf of the defendant, Mr. Wally Martinez. I stand before you today in an effort to preserve one of the fundamental rights of the American judicial system, that being one who seeks equity must do equity. While you might not look favorably upon the actions of my client, you should not be deterred from recognizing the ancient truth that two wrongs don't make a right. Thus, it is our prayer that you would grant this motion to quash service of process and dismiss this case, because the plaintiff acted fraudulently in inducing my client to both enter and remain in the state of Tennessee for the sole purpose of gaining service of process over him there.
Mr. Newman, you said that the plaintiff acted fraudulently. How are we to decide when there's fraudulent service? Is it factors, a test?
There's really not any factors or a test to be applied. An example of a case where the Supreme Court of West Virginia found that there was fraudulence in gaining service of process is a case called Tickle versus Barton. And in that case, the plaintiff's attorney called the defendant and invited him to an athletic banquet and said, hey, come, this is a banquet at your old school, we're going to recognize you, come see us. And when he got there, they served him a process. And the court determined that that was a fraudulent means of gaining service of process, which is comparable to the situation we have before us today. The plaintiff, Ms. Coburn, got my client to enter into the state of Tennessee by telling him that she possessed some information in regards to an alleged conspiracy for these police officers to get her to kill somebody for them.
You say alleged conspiracy. Is that the same conspiracy your client's been tracking for 20 years?
It is the same situation my client's been tracking for the last 6 or 7 years. It's not been 20 years, but he has been keeping up with this case. Now, it's not the conspiracy that he's been looking at. He's been just keeping up with all kinds of instances where police brutality is involved, and that's the type of situation that the plaintiff was involved in. So that's the kind of things he's kept up with. But that to say, the plaintiff acted fraudulently because while she alleged that she had this information, there is absolutely not a morsel of testimony or evidence that she can provide to show that she actually had any evidence that she claimed to, which brought my client into the state of Tennessee. Aside from that, the plaintiff acted fraudulently in her invitation to get my client to enter into the forum. A case from the Ohio Court of Appeals called Gazetta versus Gazetta tells us the importance of the invitation tells us that the invitation is an integral part of determining fraud or deceit in terms of service of process.
What are the facts of the Gazetta case, Counselor?
The Gazetta case is about a husband and a wife, right? Essentially an ex-husband and a wife. The husband went to go see his ex-wife in Ohio, and things were honky-dory at that time. But when he got there, he told his ex-wife that he was now remarried and his new wife was pregnant. And at that point, she got enraged and had him served with process. And the court said because her her intention at the time of extending the invitation was not to serve him the process, but just to arrange a meeting between he and his child, that the service was not induced fraudulently, which is not the case in the case before us today. Ms. Coburn could have easily snail mailed or emailed or by other means sent these documents that she claimed to have to my client, but instead she required that he come into the forum. That was the only way he could get those documents.
But she didn't serve him on the first day, did she?
She did
served
not.
him on the second day.
Right. So that leads to really the second issue before us today. That being, even
Well, hold on, Counselor. Wasn't it his idea to come to Tennessee in the first place?
so he did reach out to her, and initially he asked if he could fly her to New York, where she was from, where the incident occurred. But she said the only way that you can get these documents is for a face-to-face meeting, and the only place we can do it is in New Taft, Tennessee.
Well, I mean, that doesn't really seem like she was trying to trick him into coming to Tennessee. It seems like she had what he wanted, and so if he wanted it, he should
Well,
come to her.
If she did indeed have those documents, then yeah, it's possible that she was not acting fraudulently. However, again, there is not a morsel of evidence that those documents existed.
Has she admitted that the documents do not exist?
She has not admitted that they do not exist, but she has, on numerous occasions, failed to speak to the status of those documents. She says she no longer has them, but we don't know if they ever existed to begin with.
But you would agree with us that the record does contain evidence that Ms. Coburn showed Mr. Martinez a new document that he did not have on the first day.
A new document that did not contain any new information. She claimed that the documents that she had were newsworthy and contained new information. However, all the documents he received on the first day, while one was a new document, the information contained in it was not new. So, Your Honor, even if you all do not believe that the plaintiff acted fraudulently in getting my client to enter into the forum, there should be no question that she acted fraudulently to get him to remain.
Do we have to find that there's fraudulent inducement before we can find there was a fraudulent intent to make him remain?
No. Even once he entered into the forum, if he is fraudulently required to remain, then service is still improper. The Kmart versus Genstar case out of the U.S. District Court in the Eastern District of Michigan tells us that the plaintiff must first make a bona fide effort during settlement meetings before service process can be served properly. And so in the first meeting between my client and the plaintiff, she alleged to have these documents the first day in the trunk of her car. However, she lied to my client and said that she did not have those documents. Had she had those documents and had good faith intentions and was making a bona fide effort to settle the dispute between the two of them, she would have given them those documents and made the exchange on the first day.
Is this not okay?
Sorry. Counsel, let's talk about the morning of April 9th when the service of process occurred. How is the meeting between Coburn and Martinez there not a bona fide effort? It says in the record that they did actually have a partial meeting before deciding to serve the process. How is that not a bona fide attempt?
The second day's meeting?
Yes.
Well, obviously, as I mentioned, the first day's meeting was not a bona fide effort. And the second day's meeting, it was clear that she had already had these documents drafted, and it's clear that she had already formed the intent to go ahead and have him serve the process while he was in the forum. She had these documents drafted the day of the first meeting. So I would say that the second day's meeting was merely perfunctory because she was already taking steps towards serving him the process, thus not providing a bona fide effort.
Is this not just a case of buyer's remorse? Mr. Martinez thought he was going to get something grand, got up there, didn't like what he got, and now he's mad?
I would not say that's the case, Your Honor. I think that my client was expecting to get something significant, which he had been promised, and he did not. Simply did not get anything newsworthy, anything new, contrary to what the plaintiff had promised him.
So your client's opinion of newsworthy and explosive should bind this court to find Ms. Coburn's service of process invalid? Because aren't we just talking about mere adjectives here?
The plaintiff said that she was going to provide my client with documents that he had not seen, with new pieces of information, and that simply was not the case. She simply did not do so. And there is no evidence, again, that she had any such document, which reiterates the fact that she acted fraudulently. In addition, in regard to requiring my client to remain in the forum, the same case, the Kmart versus Genstar case, says that when a defendant should receive a warning either before entering or after negotiations fail in a settlement situation. At no point before entering the forum or after negotiations failed did the plaintiff give my client any sort of warning about the possibility of being served with process in the state of Tennessee. And clearly, that violates the rule out of Kmart. Therefore, I would stress the fact that this court should follow the direction of the Kmart court and rule that that service was improper because my client didn't receive a warning.
Well, counsel, let's say that the motion to quash is granted here. What happens to this case?
So if this motion to quash is granted, and this case will be dismissed, the plaintiff could try to file again and serve my client with process again properly. But if this case is dismissed as it should be, then this case will end at this point.
What are the public policy arguments, not for your case, but against your case, if we were to find for Ms. Coburn?
The public policy arguments against my case. Your Honor, I really think that the court should rule in favor of my client for a number of reasons. And I honestly cannot think of any public policy reason why the court should rule in favor of the plaintiff.
Well, give me your public policy reason then.
One of the Tickle versus Barton case said that a plaintiff should not be able to do a wrong and upon that build a right. And so, in terms of public policy, a plaintiff should not be able to serve somebody with process fraudulently and get rewarded for it. Be allowed to proceed in litigation when the service of process was based upon a fraudulent means. Lastly, in regards to requiring my client to remain in the forum, the case of Oliver versus Cruson out of the U.S. District Court in the state of Montana said that a defendant must be afforded a reasonable time to leave when the purpose of the parlay cannot be achieved. My client was not allowed to leave the plaintiff's attorney's office, let alone the state of Tennessee. So, Your Honors, for these reasons, we ask that this court grant this motion to quash service of process and dismiss this case. Thank you, Your Honors.
Plaintiff, are you ready?
We are, Your Honor. May I proceed? May it please the court, Your Honors, opposing counsel. My name is Karmel Keaton, and I represent the plaintiff, Ms. Mary Jo Coburn, in opposition to the defendant's motion to quash service of process and dismiss. Today, the record and case law will show that service of process was proper and should be upheld as such. As a matter of public policy, to not only protect citizens' rights to privacy, but to protect their right to due process, fair legal proceedings, and the right to be heard, this court should not quash service of process and dismiss. Service of process should be upheld primarily for two reasons. First, the defendant was not fraudulently induced to enter the jurisdiction because he entered of his own volition. Ms. Coburn did not fraudulently induce or employ any scheme to bring him within the jurisdiction. Secondly, the defendant was not fraudulently induced to remain within the jurisdiction because Ms. Coburn acted in good faith in attempts to settle the dispute, which is evidenced by the 2 bona fide meetings she held, as well as the time frame in which she served the defendant. Now, the general rule that governs proper service of process comes out of the Supreme Court case Commercial Mutual Accident Company v. Davis, which states that if a person is induced by artifice or fraud to come within the jurisdiction of the court for the purpose of procuring service of process, such fraudulent abuse of the writ will be set aside upon proper showing. Furthermore, the court may be persuaded to find that service of process is proper if a bona fide attempt to settle the controversy between the parties has been employed, and only when that attempt fails is service of summons made. Now, here in Ms. Coburn's case, there is not a proper showing of fraud. The defendant entered the jurisdiction of his own volition. Now, in the Connecticut Superior Court case Bobador v. Abnor, the court held that service of process was proper because the husband defendant entered the forum voluntarily. Bobador was a divorce case in which the husband defendant entered the United States in search of his wife and daughter and was subsequently served when making arrangements to see his daughter. The court stated that it will not exercise jurisdiction in a case which is based upon service of process on a defendant who has been decoyed, enticed, or induced to come within the court's jurisdiction. However, this rule does not apply when the defendant enters the state on his own.
So counsel, are you saying that the court has essentially created a rule where on the volition standard that you're asking us to look at, that they would basically have to drag a defendant into the forum? I'm sorry, I'm not seeing how a defendant would not go into a forum of their own volition outside of physical inducement.
Yes, Your Honor. With that, if they do come voluntarily, then they are subject to service of process. But even more so, which Bobador also points to, is that once they voluntarily enter, even if they are then enticed by the plaintiff, that they are still subject to service of process and that it should be upheld.
What authority is this court to look to when looking to determine if there is proper service of process?
With that, Your Honor, as a first impression case, we ask that the court look at the Commercial Mutual Accident versus Davis, the Supreme Court case, as well as its applications, which are present in Kmart.
Are there any statutory or uniform rules that we are to look at when we're determining whether or not service of process is proper, or if this court even has jurisdiction to hear the matter today?
With that, Your Honor, the federal rules of civil procedure 12B 5 does go towards insufficient service of process, but in this instance, we contend that there was proper service.
But what statute are we looking to for proper service? I get 12B5 and 12B6 to dismiss, for which Mr. Martinez is asking, which statute or guideline are you saying that service is proper under? Why are you here today?
Yes, Your Honor. We go with that, when they do bring up insufficient service, the burden moves over to the plaintiff to show that service was proper, and that comes from Lopez versus the municipality of Dorado out of the Fifth Circuit, that we have to prove that service of process is proper. With this, the defendant's own testimony actually speaks towards his voluntary entry. He actually told the court that he was the one, that he rearranged his schedule to come to New Taft. Furthermore, that he purchased his own tickets, to come to New Taft, and that he met with Ms. Coburn because he was interested in a newsworthy story. Now, with that, as an investigative journalist, he should be wholly aware that in any state that he conducts business in, that he would be subject to service of process. Now, in Century Brick Corporation versus Bennett, which is a Pennsylvania District Court case, the court actually quashed service of process. And in this case, the plaintiff called the defendant who lived in New York to come to Pennsylvania on the pretense of a job assignment, when in actuality, all he wanted to do was procure service of process. Now, that is not the case that is not the case in our case here today. Unlike the plaintiff, Ms. Coburn actually intended to meet with the defendant.
But she never intended to give him any documents.
Yes, she did, Your Honor. She intended to exchange information, and in her testimony, she actually stated on page 52 that she wanted to persuade the defendant to return the tapes, and she didn't actually want to be involved in litigation.
Where are the documents then? If the defendant never received the documents, so.
Yes, Your Honor. With that, while it's correct he did not receive the documents, they were trying to negotiate and bargain quid pro quo. He was not willing to promise her that those tapes would not be released when he did see the documents. So in negotiating in good faith, he was not willing to provide those promises. So she was, in that instance, did not want to give everything over to him, in which he could then thus go and publish the tapes.
Hasn't she admitted that she told a little white lie to get the defendant to come to the state in the first place?
No, Your Honor, not as far as in coming to the state. She did provide an offer in which she did not decline to come to the state. The only time in which she admits to a white lie is during that second meeting, during that second meeting that she's already held one bona fide meeting, and it was that second meeting that she wanted to delay and have a little bit more time, that way she could bring a witness to those proceedings, and that way she could also get further documents that might be more newsworthy.
Well, you mentioned bona fide, counselor, and I want to talk about that for a minute.
Yes.
Isn't it true that your client's on her way or the highway? If it didn't go her way, then she wasn't going to produce any documents. Therefore, that's really not good faith and fair dealing. So, in my eyes, there would be no negotiations at all, which would mean Mr. Newman would be correct that this was solely for the intent of service of process. How can you rebut that?
With that, Your Honor, I would also, to rebut that, the defendant also, there has to be a quid pro quo. The defendant was not willing to promise not to publish the tapes. She did provide 2 meetings that were bona fide. She didn't immediately serve the defendant. She had the first meeting in which she did produce documents that she felt was newsworthy. She testified, however, that she was not aware of what the defendant would find newsworthy or not. To her knowledge, they were newsworthy. And when he advised that they were not up to his standards, she then held a second meeting in good faith, again, trying to negotiate. And at that meeting, when he no longer wanted to negotiate, he was not willing to not publish the tapes and tell her that, is when she then served him. She was still trying to negotiate with him during those meetings. And
is she still trying to negotiate now? Because from my review of the record, Ms. Coburn has still failed to produce the documents to Mr. Newman's request to actually see the documents before court today. So is this still Ms. Coburn's negotiations?
No, Your Honor. With that, the documents are no longer in her possession, so she is not able to actually produce documents that she no longer has. Now, with that, citing the commercial Supreme Court case, the court in Kmart Corporation versus Genstar Industries Company held that service of process could be upheld if there was a bona fide effort to settle immediately before service, or if the plaintiff warned the defendant about the possibility of service before entering the jurisdiction. Now, the defendant spoke to this rule. With that, the court provides 2 options to fulfill this test. And again, we do ask that the court follow commercial's rule in its application here in Kmart. Although she did not warn the defendant about possible service of process before he entered the jurisdiction, alternatively, she did have that good faith effort in providing those 2 bona fide attempts. Kmart also held that good faith in settlements can be exhibited by the plaintiff giving the defendant an opportunity to leave the jurisdiction before service is made. And that is the case that happened here today. After the first meeting occurred, he had the opportunity to leave the jurisdiction, but the defendant chose to remain. He actually stated that he figured he had gone this far and he might as well see it through, so he agreed to stay over. And that was on page 20 of the defendant's testimony.
Wasn't the entire reason that he decided to stay was that she said she had those papers? Isn't that the entire reason that he remained in the forum for the next day? Back to the little white lie that you were talking about earlier.
With that, yes, Your Honor, I would say that is he was wanting newsworthy information. But again, Bobador does tell us that because he came voluntarily for that first entry, the rule does not apply if the plaintiff then engages in some type of trickery to make service a process. So despite that white lie, he had already voluntarily entered and was therefore subject to service of process if it did occur.
It just seems to go completely against public policy for us to say he can come to the state and then the plaintiff can lie to him about whatever document she has, but we're still gonna say service was good because the reason he came in the first place was technically not deceit. Doesn't that just give you a bad feeling, counselor?
With that, Your Honor, she did attempt to make a good faith negotiation, and then after there was that little white lie, but nonetheless, the rule does not apply as we do see in Bobador.
I hear you say the Bobador case, counselor. What's your position, or how are you rebutting the fact that this very court requires that the defendant be given a chance to leave the jurisdiction before service of process can be had? And Mr. Martinez was not even allowed to leave Ms. Coburn's lawyer's office before he was served with process, not even allowed to get out the door, much less to leave the jurisdiction. So are you asking this court today to change law that's been written for 60 years?
No, Your Honor. With that, he was given the opportunity to leave prior to that meeting. He chose to remain for his own personal gain. He had the opportunity to leave, and yet he chose to remain. So in that instance, he should be subject to service of process because it was his voluntary choice.
But if it takes 2 to negotiate, and it's your client's position that this was a bona fide, good faith negotiation, and he came to the negotiation, should he not be then allowed to leave the negotiation before he's bombarded with service of process?
With that, Your Honor, the only reason she then rendered service of process on him is because he no longer wanted to negotiate in good faith. He was not providing quid pro quo. So in that instance, she saw nothing other. She saw that she could do nothing more than but to serve him with service of process.
Well, that was not. But didn't she get her lawyer to prepare the papers, and not only prepare the papers for this action, but they actually engaged a process server on April 8th before the April 9th meeting? Why would you engage a process server if you weren't getting ready to serve somebody in the forum?
Again, Your Honor, she did state on page 52 that she did want to persuade him to return the tapes and not to litigate. With that, in Oliver v. Cruson, the U.S. District case out of Montana, it is similar to the situation. I do see that my time is running low. Is it okay if I respond and finish with the question, please? Thank you, Your Honors. In the Oliver v. Cruson, which is similar to this case, well, unlike this case, that defendant, he filed papers 4 days prior, and when the defendant was on the plane to the jurisdiction, he actually processed papers and immediately served him when he got off the plane. But in our case, there was one whole meeting that occurred. He stayed overnight, and then at the end of their second meeting, when she saw that the defendant was no longer going to negotiate in good faith and provide quid pro quo is when she served him. So in that instance, there was good faith, and he was not immediately served. The process server also stated on page 69 that there was some sort of negotiation and that it might be possible that it could work out. So she had already planned to negotiate with him to return the tapes, and litigation was the last thing that was on her mind. It was only when negotiations began to break down that she then served him. So in this instance, Ms. Coburn has met her burden of proof. Service was proper and should be upheld. Therefore, the court should not quash service of process and dismiss. Thank you.
Your Honor, may it please the court. The plaintiff, time and again, cited the Babowder case. However, this case is night and day from Babowder. In Babowder, the defendant was already in the forum. He was already in the state of Connecticut, already in the United States, when he made the contact with the plaintiff's attorney and arranged the meeting. He had already voluntarily entered the forum. In our case, however, my client entered the forum because the plaintiff fraudulently induced him to do so. It was not voluntary. It was fundamentally different.
Counselor, I'm going to ask you the same question I asked your opposing counsel. Under what rule are we to find whether service of process was proper or was improper?
Your Honor, in terms of a statutory provision to provide that, I'm not entirely certain of where that would come from. But in terms of case law and in terms of public policy, I think that my client should prevail. Because the fact of the matter is, this was not a good faith negotiation. In reality, my client arrived on the first day, agreed to remain for a meeting the second day, and when he showed up, as soon as the negotiations failed, he was served by a process server who was sitting outside the room waiting on him. Thus, in accordance with good public policy, we ask that this court grant this motion to quash service of process and dismiss this case. Thank you.
It's squashed.